So here we are again to the last panel. The last panel, we will have 5 speakers, and maybe we will also say something. I already said too much. Me and Eloisa. This is supposed to be a roundtable on the prospects and challenges of international climate litigation. We have representatives of systems, but also people who study specific aspects of international litigation, crossing with the environment. We hope you are all online. We have Pedro Rosa Có. I'm not seeing him. Is he with us? It looks like a spirit thing. See with us. But we have Anarita Gil. She's here on my right. I don't know if Corina is with us.
Yes, she is.
Yes. Leah, I think she is. Yes.
Yes.
Okay.
She is.
And Kathleen?
Yes,
Yes, Kathleen. Hello again. We met some months ago. I was very impressed with her presentation. How are you, Kathleen?
Thank you so much, Madam Chair, for your kind words. Wonderful to see you again.
Oh, I think
Pedro Rosa Có is now online.
Is also
please
online.
open the window, not the window, I'm sorry, the video. I'm sorry, I'm very tired, so I'm going to start saying strange things.
Well, we will start with Pedro. He is online right now. Pedro Rosa Có is a Master of Laws from the University of Lisbon, and he is currently a Senior Legal Officer and Head of Communications Coordination Team at the African Commission on Human and People's Rights. He is a former Senior Legal Officer at the African Court on Human and People's Rights. We will start with him. Pedro, it's a pleasure to have you with us. How much time does he have? 10 minutes?
Yeah, around 10 minutes, then we'll go for discussion.
Around 10 minutes, Pedro. The floor is yours.
Thank you very much for giving me the floor. I think it's good afternoon for you. Yes, we are already in the evening. I'm very happy to join you for this panel. And the Faculty of Law, University of Lisbon is my house, and though I'm joining you through a virtual meeting or virtual conference. My feeling is that I'm back to my house where I graduated. I had my post-graduation diploma and my master's. It's also a pleasure. I can see Professor Loreto Pastor is no longer there. He was my supervisor for my master's thesis. And I take this opportunity to thank Professor Kalamadu for inviting me and for giving me the opportunity to join you. This is a very interesting topic. It's a new one. By the discussions, we can see that the system is still struggling to reshape itself to accommodate the challenges that are coming out when we are dealing with the issues of the climate change, of environmental changes, and the human rights. My topic will be focused on an African Union human rights system, which is composed of 4 organs, which is the African Commission on Human and People's Rights, the Committee of Experts on the Rights and Welfare of the Child, and the African Peer Review Mechanism. So I will focus on the African Commission and the court, and I will try to bring and share with you the mechanisms that are available within the African Union system to deal with the climate change issues and environmental issues in general. But I think before going to the point or to the topic we are supposed to deal with it, I think it's very important to share with you other mechanisms other than litigations, because in African Union human rights system we still have the Commission that has a promotional mandate. So it's very important, I believe, to share the mechanisms that are available within the African Union, Africa, that can be very important, useful to deal with the issues of environmental rights and climate change. I'm referring to the promotion missions, the commissions of inquiry, the periodic activity report, the periodic report from the states, the letters of urgent appeal, letters of concern, and the mechanisms that are available within the working group on extractive industries, environment, and human rights violations. And then I will, in the second phase of this presentation, focus on the protections and the climate change. So, starting from the promotional missions, the African Commissions do promotion missions under Article 45 of the Charter. During the promotion missions, the commissions engage with the states and the civil society and discuss with them the situations that are related to human rights. So if we look at it in the perspective of the climate change, it will be also included in the discussion during the promotion missions. The same for the Commission of Inquiry. The Commission can create by its own initiative the Commission of Inquiry, or can also be could do so under request of the political organs of the African Union. So those commissions of inquiries can also be related to the issues of climate change. Same for periodic reports by Article 62 of the Charter, and also of the Maputo Protocol and the Kampala Protocol. The Commission, the states parties of these three instruments are obliged to submit periodic report to the Commission after 2 years. So when they are obliged to have a specific item that is related to the Article 21 and 24 of the Charter. But these two articles, they are related to the right to environment. And right to environment is nowadays could be read in a way to also take into consideration the issues of climate change. There is a guideline, reporting guidelines on these two articles. So a state, when they are submitting their periodic reports, they have to demonstrate to the Commission how they have been dealing with the issues related to the right to environment and the climate change. And we also have the letter of urgent appeal. If anything that happened in the territory of the state parts to the Charter, which is related to the climate change of the right environment, the Commission has the power to write a letter of appeal urging states concerned to report about the measures that has been taken to deal with the situation. I'm thinking in the case of floods, the case of natural the causes that can put in danger the life of people or have impact on the environment. So when these kind of things happen, states are obliged to take measures, and they have to report to the Commission on which measures they have taken and challenges they're having. And normally when the Commission sends a letter of appeal and the state does not respond to that letter, the Commission, when it's preparing it and submitting its report before the political organs, has to indicate that it has sent a letter of urgent appeal and the state did not respond to it. And if it was the case also the state has responded, the Commission should also indicate that it has received the response from the state and the response is enough, or it is if the Commission considers that the state has responded to the question he has raised. And the same also for the letter of concern, where the Commission can send a letter of concern to states about the situations where there's an alleged violation of human rights, and ask states to provide information in that sense. The Commission has the Working Group on Extractive Industries, Environmental and Human Rights Violations. So this working group deals with the issue of the environment, including the issues of climate change. These mechanisms, but we should look at them in the context of the African culture, where we say that in Africa we talk, and by talking, sometimes it's better to get the solutions instead of litigating. So litigation is was seen. Right system was set up, and the discussion was going on before the setting up the African human rights system. The conclusion was that in the African traditions, litigation wasn't the main way to get a solution to problems. So it's better to have a soft mechanism. The reason why the Commission was created, instead of creating going straight to have a court. And in 1998, having a court. So this mechanism, they look soft, but they may be very efficient on dealing with the issue of climate change. Actually, I'm convinced that the climate change is not something you will be efficiently dealing with it through litigations. In any case, I will now move to the second phase of my presentation, which is litigation. When it comes to litigation, we have two, as I said, two bodies I will focus on, which is the Commission and the African courts. In terms of jurisdictions, the two bodies, it is required to assess the four conditions of jurisdictions, which is personal jurisdictions, material jurisdictions, the temporal jurisdictions, and territorial jurisdictions. Starting with the personal jurisdictions, before the Commission, we have two mechanisms or two types of communications, which is interstate communications provided for under Article 47, 48, and 49. And we have other communications, which is related to the individuals, communications submitted by individuals and NGOs. The same thing before the court. Article 5, 1 of the court protocol provides the list of entities that can access the court, starting from the commissions. I think we are here we still have the commissions, which is no longer exist in the European Union system. We have the commission who can seize the court. We have the states that can also seize the court. We have the state who can act on behalf of the victim, of a citizen, and lastly we have intergovernmental and African intergovernmental organizations from Africa. So, in case of individuals, NGOs, these two entities, they can only access the court if the state concerned has filed the declarations of Article 34.6, which allows the direct access for individuals and states.
Pedro, I would
we can say that in terms of access, the African human rights system seems to be more open, because it allows for action popularis. And in some situations, the court has gone further to allow the in abstracto control of conventionalities. In a case opposing APDF and IHRD against Mali, the court has considered in abstracto compatibility of the Malian Code of Family, and the court found the violation of the Maputo Protocol, they found the violations of the conventions on all elimination of all form of discrimination against women, and also find the violations of the African Charter.
Pedro, you must
right, and
conclude, please.
Yes, I'm going to conclude. So in terms of the jurisdictions, as I was saying, the African human rights system seems to be more open, and it offers the tools and mechanisms to deal with the challenges the other systems are having on dealing with the cases of climate change. In any case, I think that though it's open, we cannot, the climate change litigation cannot stand alone before the system. It has to be linked with the human rights instrument that exists. You cannot, when you claim the violation of the obligation of state in the context of climate change, you have to link it with the provision of the Charter and any other instrument that exists in the system. I think we will have a time during I wanted to share with you some cases of the Commission and the courts where the environmental issues was raised, but maybe we leave it for the discussions. Thank you very much.
Thank you, Pedro. Sorry for intruding, but we have a short time, so we can debate after the presentations. We have Professor Ana Rita Gil now. She is a professor at the University of Lisbon School of Law, a researcher at Lisbon Public Law Research Center. She has a PhD in Human and Fundamental Rights Law from the Faculty of Law of the New University of Lisbon. The thesis is on site protection of immigration fundamental rights. And she is also an independent researcher in several studies for the European Union, for international consulting companies, and for international academic networks. Ana Rita, thank you very much for being here with us. The floor is yours.
Thank you. Thank you so much. I would ask, please, for my, here it is. Thank you so much. First of all, thank you for the invitation and congratulations for such a wonderful day. It has been such a good debate. I've been learning a lot. Without further ado, as you can see, now we are going towards a quite different topic, because my field of research is migration law, which is strictly connected nowadays with climate change, as we all know. So some previous notions, I don't want to bother you too much with this, because sometimes migration scholars do spend hours and hours debating on concepts. So just to know that when I'm going to address about climate migrants, and irrespective of all these different terms that we can use, I want to refer to people who are forced to move from one country to another due to climate factors. So a forced movement, forced displacement, and an international movement, because we can have as well internal displacement. So I'm not going to go into the internal issues. And we can see here some quite alarmistic data from the World Bank that claims that by 2050, we will have all these millions of displaced persons due to climate factors. And they also claim that climate and environment will be the major cause of displacement, more than wars. Of course, we never know, right? Because we are now facing wars that we wouldn't imagine, but still this is quite an alarming thing and scenario, and we should think how can we deal with all these displacement numbers. First problem, as regards migration law in specific, I'm not going to bother you too much with migration law, but just so you to know that migration law itself does not provide an answer to these people. So they don't have a protection status, neither of the international or regional instruments that are in force, either globally, such as the Geneva Convention on Refugee Status, or the regional arrangements in the three systems. Neither of them provide a protection status to people who are forced to flee due to climate factors. We have protection for persecuted persons, but for persecution there has to be a human action. So nature itself is not a human action, cannot be encompassed by the notion of persecution. And secondly, for mass movements, we have solutions, yes, but just for conflicts or general disturbance situations. And here I have to say that the African system is more advanced than the others. And here in the EU as well, we have the subsidiary protection and the temporary protection, but just for conflict situations. So no solution for mass displacement of climate migration. So what type of litigation is to be expected in this regard? I designed here the typical scenario that already happened, not in a court, but we will see. A migrant asks for international protection in a different country. He claims that his or her country of origin does not offer enough conditions of living in a dignified manner, or even does not allow these people to survive in the country due to drought or rains or inexistence of a possibility of growing crops. And the request for protection is denied by the national authorities. So the litigation in the international court will be against this decision that denies the protection. And this is here that we are trying to build a way to protect these people that, in my opinion, may not be forced to go back to their countries if, due to climate factors, they do not offer sufficient and dignified conditions of living. So how did we do it? How are we doing it? Again, since migration law does not offer protection, as in the climate litigation, we are going towards human rights litigation. And to the, this is the French expression used by the European Court of Human Rights, the protection par ricochet. So what we do, we claim that this person cannot be returned to his or her country of origin because there they will suffer a violation of a right that is protected by the European Convention of Human Rights. Okay, so this is moreover what we've been listening so far. And so this is the same type of litigation with a difference. Here we are claiming the right to life, but in all that is connected to migration, it's very common to claim the prohibition of torture, because this is very related to the non-refoulement principle, which is a principle very specific of migration law. So not as much Article 8, which is something that is used quite a lot on climate litigation, but mostly on climate migration, Article 2 and Article 3. This is a particularity here that is different from all that we've been listening today, is that here we are claiming protection to a state irrespective of the question of whether this state had some responsibility on the environmental damage or not. It's just because I am in this state at this moment, so this is quite a very by chance situation, that I claim his or its protection. So there are no links to causality, to responsibility. All that we've been discussing so far is not used here. So the main reason why I'm asking protection to this country is because I managed to flee to this country and I cannot go back to my own country. So irrespective of particularly considerations of responsibilities. However, migration, human rights litigation on migration matters has a big weakness. Is because, and this weakness is due to the sovereignty principle. For the European Court of Human Rights, and not only, states should be free to decide who enters and who remains in their territory. So when we are trying to impose someone in the territory, like you have to give protection to this person, you have to give residence to this person, this is something that goes against this dogma of the state sovereignty, of the territorial sovereignty. And this is why human rights litigation on migration provides very weak responses, because the courts have to balance the sovereignty principle with the human rights, and human rights are seen here as an exception to the sovereignty principle. We will see in practice how does it work. I'm bringing some examples, one from the European Court of Human Rights, and another, it is not a court, but it was like the big first decision on migrant climate migration. So we will see how this works in practice. The first one, I have to say that this is something that I argue that this is kind of the first climate migration case in the Strasbourg court, but this is not broadly accepted. So this is like my creation, because it was not a migration that was caused by climate change, okay, no, but it has some elements connected to environment that can be used as a precedent for further situations when the court will have to deal with climate migration. So the court has not dealt yet, but in the future may deal. And I think that this case can be a good starting point. So we have two asylum seekers fleeing Somalia. They asked for asylum in the United Kingdom and it was denied. They came to the Strasbourg court and claimed that the capital city of Mogadishu was full of violence, and in the refugee camps there was a very dire humanitarian situation. So drought, non-potable water, and also other factors such as overcrowding. And this, in the opinion of the persons, would amount to ill treatment. The court agreed. The court agreed and claimed that the return to Somalia would indeed amount to a violation of this Article 3. And we are mentioning prohibition of torture, inhuman and degrading treatment due to causes of environment. So drought, non-potable water, and other consequences that followed and helped to reach this conclusion. So the court claimed, of course, that in this case, it was very exceptional. In order to achieve this threshold of violation of Article 3, it has to be a very, very serious situation, so very severe. And in the case, there was not only violence, so they could not go to the capital city. The only alternative was to reside in the refugee camps where the environmental conditions were very severe. So there was here a clear element of environment in the decision that amounted to ill treatment, to stay with non-potable water, with overcrowding and so on, would amount to this violation. As for the, sorry, I forgot. As for the Human Rights Committee, so the Human Rights Committee issued the first international decision on climate migration. As we know, this is not a jurisdictional body. It is the monitoring body of the International Covenant for Civil and Political Rights. And as we all know, people can, for those states that have signed the optional protocol, they can address individual complaints to this committee. So we had these nationals from Kiribati who asked for asylum in New Zealand. And they claimed, again, human rights litigation, they claimed, if I will be returned to Kiribati, I will be subjected to a violation of my right to life. Why? Environmental factors again. No fresh water, sea level rise, they were trying to combat, but it was being impossible. So the inhabitable land has eroded, housing crisis, environment was violent. The environment was violent. So what did the Human Rights Committee stress? He agreed, well, the expulsions should be forbidden when they lead to irreparable harm. In general, the risk must be personal, but in most extreme cases, like this one, which was a general risk, it would not affect just these 2 asylum seekers, but the general population. Yes, we can provide protection, but if all the general population is being affected, this is very important, we have to have a really higher demanding of the burden of proof of a very severe situation in order of what? To impose a second state to receive all the asylum seekers. Another important thing that Human Rights Committee claimed was that environmental degradation indeed was one of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. So yeah, he agreed that this environmental degradation was connected to the respect of the right to life. However, in the case, the committee considered that the severe threshold for very extreme circumstances was not met. He considered that the supply of fresh water was not that bad in order to impair the right to enjoy a life with dignity. So there was still some possibility to enjoy this fresh water, although it could be not that much, but still some. And the sea level rise they set this time frame. Well, this sea level rise allows for 10 to 15 years before becoming too unbearable. So there are 10 to 15 years for the state to act before we have to impose protection from the other states. Well, I have to say that there were some interesting dissenting opinions. One of them actually claimed, so do we have to wait for deaths to occur before considering that the risk was met, that the risk is met? So we have 2 dissenting opinions. There are not that many, but it was quite illustrative. And to finalize some conclusions from these 2 cases that I mentioned, one was successful, but the European Court proved that it was successful because of the very extreme and exceptional circumstances. And the other was not successful yet, we have to say yet, because it had not yet achieved the high threshold of serious threat to life. But we can say that when it comes to migration, we demand a more demanding burden of proof, a real risk of irreparable harm, and in the present moment. So no protection for foreseeable situations of degradation. So it has to be happening now. And this is related to the problem of sovereignty, and the human right has an exception. We can provide though more protection if the applicant shows that there are other human rights problems like violence. So if he claims, like the first case, either I stay in the city and there is violence, either I go to the camp or there is environmental degradation, then it's easier if we just claim environmental degradation. And why is it so difficult to finish? Well, my explanation is because of this fragility of the migration litigation, which is the respect and the deference to the sovereignty of the states in order to decide who can stay and remain. Secondly, we are here when we are trying to claim fundamental rights to stay in a country due to climate situations. We are adapting things that were created for personal risks, for when there is a person that comes to a country and claims, I am being persecuted, I am being subjected to death penalty, and we are adapting this to a situation that affects a big amount of people. So that's why it's more difficult in these situations. Finally, I have to say, I thought a lot, why is it so difficult to provide protection in these cases? And I think that there are some similarities for the states, and for me this is a political issue between climate-induced migration and poverty-induced migration, because there are many countries where it was not due to climate change, but their natural resources are scarce, and states are afraid of opening the doors to when we have climate change and resources became scarce, this may become too similar to situations of poverty where scarcity was the original stage. So I think that there are some fears of opening the doors to economic or poverty migration. So these are my thoughts about this, and thank you very much.
Thank you, Ana Rita. We are now going to hear Corinna Harry. She's a postdoctoral researcher at the Institute of Law of the University of Zurich, and she has a PhD in law by the University of Zurich. Corinna, we are all expecting to hear your presentation.
Thank you very much for the floor. I'm just trying to share my slides. So if you could give me a thumbs up if that's working.
Yeah, they are already here.
Perfect. Thank you. And thank you also for bringing us together here today. I would have loved to be there in person, but it's been a really interesting day for me as well. So thank you for the invitation. So we've already heard quite a bit today about the European Court of Human Rights. I'm also going to talk about the European Court of Human Rights, and I know that the remaining presentations will as well. I won't talk too much about the background of my talk, about the cases, because we heard a lot about those this morning. We all already know that the European Court of Human Rights has a number of climate cases pending before it. 3 of these cases are pending at the Grand Chamber, and you see the applicants in some of these cases pictured on the slide. I'm expecting you're familiar with the broad strokes of these cases. They're 3 different cases, but they're also similar in a number of ways. So they all at least invoke Articles 2 and 8 of the European Convention on Human Rights, so respect for the right to life and the right to respect for private and family life. They all contest the impacts of climate change on the applicants, and they all demand mitigation. Now, as you've heard this morning, we don't have judgments in these cases yet, so I can't discuss the outcome of these proceedings, unfortunately, yet. But we do have is an ongoing discussion about the challenges facing these cases, which is also what I was asked to speak about today. Now, the European Convention system was not designed with these climate cases in mind. It wasn't even designed with environmental rights in mind. And as we heard, there's no right to a healthy environment in the convention, but the court has greened the rights that we do have in this convention, has applied them to environmental cases, and it's heard upwards of 400 environmental cases so far. Arguing these cases isn't always straightforward. That doesn't make these cases unwinnable by any means. I don't want to imply that, but it does make them challenging to argue. So I want to talk about a few of those challenges and hurdles. I'll be picking up on different strands of what was discussed earlier, and trying to bring some of those things together. So the first group of hurdles that I want to talk about are procedural hurdles. So that includes victim status requirements. And here, when we talk about who has the ability to bring these cases to the European Court of Human Rights, we can really dig into critiques about the anthropocentricity of the convention system, the individualism of the convention system. So these rights are guaranteed to human individuals, meaning that it's both hard to bring collective or representative claims and to litigate for the environment. So to tie this into the discussion from earlier, it's very difficult or nearly impossible to litigate for a forest, for example, but it is possible to litigate for impacts on individual rights caused by those damages. What we have here also is very limited representative standing for NGOs. So in that sense, victim status is a real hurdle and a real challenge to contend with. Then you also have the matter of extraterritoriality, so the question of whether states can be held responsible for impacts in other countries, which Lea Reible will be talking about later on, and she's the absolute expert on this, so I will stop there with that question, but that's another issue. And then you also have the non-exhaustion issue. So like in the Duarte Agostinho case and other cases pending at the court, you have the fact that domestic proceedings were not always exhausted before these cases were taken to Strasbourg. Actually, in the Duarte Agostinho hearing, the entire hearing that we had this September was dedicated to the admissibility. So the admissibility issues raise a lot of really high hurdles to these kinds of cases. I've argued elsewhere that it's definitely possible to overcome these hurdles, but it's not necessarily easy. If a case manages to take these hurdles, so to pass the procedural and admissibility hurdles, then we get to the substantive questions. And that's the question of which rights are violated, which states are responsible, and how do we prove causation between emissions, climate change impacts, and impacts on individual rights. Here we're seeing applicants relying on climate science to prove that there's a link between climate change emissions and rights impacts. And I'll leave all further discussion of this issue to Carolyn Suliok, who's the foremost expert on this topic, so I won't go into that anymore either. I appreciate being allowed to speak before both of these speakers, so I can simply delegate to them. What we can also talk about here is the difficulty of capturing prospective and cumulative risks. So most judgments by the court look at events that have already taken place and where only one state is responsible. Where harms are still in the future or haven't fully manifested yet, we see applications that invoke positive obligations, as discussed this morning by Vladislava Stoyanova. So the obligation to protect against these harms. My assessment here is that positive obligations can't be used to contest every negative impact of climate change, but when it comes to the impacts on human life, health, physical and psychological integrity, they're actually very promising. So the existing case law holds a lot of building blocks that can be used to make a climate-related argument. Now, we could talk a lot more about the merits of these cases. For example, we could talk about how we're still in the first wave of climate cases at the European Court of Human Rights. So we're still very focused on Articles 2 and 8, so right to life, right to respect for private and family life. And we still need to better explore and understand the full palette of rights that are and will be affected as climate change progresses. So among other things, that includes the prohibitions of discrimination and torture. That's all I'm going to say at this point about the substantive hurdles. In light of time, I'd like to talk about a third challenge, which is the remedial hurdles facing these cases. So the question is, what can the court actually do if it finds that climate change is violating human rights? And it's difficult to redress systemic issues through individual human rights cases. It might not be enough for the court to just find a violation of the convention. And here we're going to need to explore what other possibilities the court might be able to deploy in this context. So elsewhere, I've talked about what I call the court's remedial toolbox and the different possibilities that exist if and when it's found a violation in this context. So, for example, it can award amounts of money in just satisfaction. And while it can't invalidate domestic law, it can instruct states to amend that law through a general measures order. It's not entirely clear if the court will be willing to use these powers. And to understand why that's the case, we need to look at our final hurdle, and that's the institutional hurdles. So the institutional backdrop of these cases. So the reality is that the court is an overworked and contested institution. These factors have led to increasing proceduralism and deference to states. And while the outcome of the climate cases is still unknown, it's already clear that as these cases progress, they're aggravating old tensions between minimalist and maximalist understandings of the convention and the role of the court. And that's because these cases challenge narrow understandings of convention rights and of the court's interpretation of those rights. So to illustrate this a little bit, I've selected one of those objections as an example. Here it happens to be coming from the Swiss government, who are pictured here in the form of their agents at the Klimaseniorinnen hearing we had before the Grand Chamber of the European Court of Human Rights this past March. And it's basically arguing that the court's going to exceed its appropriate role if it requires states to reduce their greenhouse gas emissions. So this statement invokes the principle of subsidiarity and the separation of powers, and implies that there are difficult trade-offs to be made here that the court might not be able to make or properly understand. And this definitely isn't a new position. So these arguments often accompany objections to cases perceived as actio popularis applications and arguments that the court lacks the legitimacy to make findings with economic implications. These are not new arguments, they're not new to climate cases. And if we see them for what they are, these are concerns about the power, the legitimacy, and the potential overextension of the convention. And these are colliding head on currently with demands for systemic change. So the question that we have is, where do we go from here? To summarize what I've said so far, there's a wide range of concrete challenges we're facing, and we have to understand those challenges against the background of an institution that's been decisively shaped by backlash. So this is a court that's overburdened, that tends to declare about 90% of cases inadmissible, and that's really been shaped by states pushing back against its jurisdiction. Currently, we find ourselves in what I like to call a liminal moment. So this is a new issue. The court hasn't decided much yet. And we're somewhere between silence and engagement by the court, just like in the wider Council of Europe context, we're somewhere between recognition and non-recognition of the right to a healthy environment. So it's not clear what's going to happen, but it's clear that something is coming. Now, I've been invited here to talk about challenges, and I've brought up a number of them. I'd like to wrap up by sharing some possible outcomes of these cases as shaped by the challenges that I've discussed. But before I do that, I would like to note that I'm firmly convinced that these challenges can be overcome to various degrees, of course, but they can be overcome. These cases certainly raise a lot of legal and political issues, but I'd like to take a stand against uncertainty or complexity as deterrents to engaging with these cases and thinking up further arguments. So if we want to think climate cases into the future and do that without impoverishing the convention system, it's urgently necessary that we question and continue to question objections to the court's role. And to do that, we need to accept that climate cases are a defining challenge for the court now and in the future, and we need to find ways to deal with these cases. I don't think climate cases are going away from the Strasbourg perspective, and what we need to do is find ways to deal with these cases to the best that the system allows. And that is a system, of course, that was designed to ensure practical and effective human rights protection, and we shouldn't forget that. So what can the court do? As the court finds its footing in this new context, we can discuss some alternative prospects of this litigation. And I've made a little graphic here. It's incomplete. There's many other options that we could put on here, but I've made a little graphic that arranges some of the possible outcomes on a spectrum. And it arranges them from minimalistic to maximalistic involvement by the court. And on the most minimalistic side, we have a straight up inadmissibility decision, and these could be based on victim status grounds, non-exhaustion, lack of territorial jurisdiction, and so on. And then on the most maximalist end of the spectrum, you have the possibility of delivering full intergenerational and global climate justice, for example, by recognizing the rights of future generations and ordering reparations for historic emissions and loss and damage in climate vulnerable countries. This could also mean recognizing, like the Committee on the Rights of the Child has done, that the right to a healthy environment is implicit in the European Convention on Human Rights already. And now I would like to say that I think the convention can only stretch so far. And as it currently stands, I don't think the rightmost option is something that the court has the power to deliver, at least not in full. In other words, any of these options would theoretically be possible, but they're not all equally plausible, especially against the institutional backdrop that I've discussed. We still don't know what's going to happen in these cases. What's absolutely clear is that the progression of climate change endangers human life, health, and welfare. And as a result, I've argued elsewhere and today that there's a sweet spot on this spectrum, and it's probably somewhere around there. This would be a finding that failing to reduce emissions in adherence with pathways that keep to the Paris Agreement violates convention rights. That would ensure respect for human rights in a warming world, but without an unauthorized rewriting of the existing convention. Now, there's a lot more that could be said about this. Your arrow might be somewhere else on the spectrum. You might want to add different little blocks to the spectrum. But I think that's all my time allows. And I thank you very much for your attention and look forward to discussing this further with you. Thank you very much.
Thank you, Corina, for your presentation. We'll give the floor to Leah Reibel. She is a senior lecturer in public law at Glasgow University and has a PhD from University College of London. Leah, thank you very much for being here. The floor is yours.
Hi, thank you so much for the invitation. As others have already said, this was such an interesting day for me too. Now, Paolo promised he would share my presentation for me because there were some question marks about my internet connectivity today. Is that still possible, or should I try?
We can all see it now.
Oh, that's great. Thank you so much. I was asked by the organizing committee, by Eloisa, to speak about the issue of extraterritoriality, particularly in human rights litigation, and that is what I'm going to do. It has come up here in almost every panel, so I was here for most of it and was able to listen to the other discussions, and I would like to explain. I think can we have the next slide, please? I would like to give you, I would like to explain why it has come up, why it really is an issue for climate change litigation or human rights and climate change litigation, and what might be done about it if we want to turn extraterritoriality into less of a problem or maybe no problem at all. I am going to do this by first giving you a story about the accepted models of extraterritoriality. So what is the accepted story there, and what makes a state have jurisdiction in an extraterritorial context. Then I will give you an example of how extraterritorial jurisdiction most recently has been contracted again and also how it's been expanding. And I will do that not by focusing on the details and intricacies of each case as it was argued, but instead I'm going to give you sort of tendencies in arguments, reasons, just trends too. I'm going to paint a broad picture, and then at the end of the presentation, I will relate all of that to climate change cases specifically. Right. Can we have the next slide? Thank you so much. So just as a matter of definition, extraterritorial human rights obligations, which is what is usually meant when we say extraterritoriality, are just obligations of states towards individuals that are at the time of the alleged violation, not within that state's territory. Usually, because that's the case, we want to establish another connection with those individuals specifically that are outside of the territory, and this is known as jurisdiction or extraterritorial jurisdiction. The accepted models here are territorial control, state agent or personal control, and a special connection between an individual and the state. Territorial control is most comprehensively and also it's most comprehensively and perhaps most influentially framed in Al-Skini against the UK by the European Court of Human Rights. Other human rights bodies also refer to this case, so it really is a leading one, not just in Europe. I just wanted to add that because there was some concern in earlier panels that the perspective might be a little bit Eurocentric, and it is, but there are also other factors to consider. Now, territorial control means that a state could have, even though it doesn't have sovereignty or title over territory, it could still be exercising control that looks a bit like sovereignty or title in international law. This model is based on belligerent occupation specifically. So those are the cases that's the context of the cases where this was developed. The next model is to say, well, not only territorial control creates extraterritorial jurisdiction, but also state agent or personal control. So whenever a state agent that is acting for and on behalf of a state is exercising control over an individual abroad, that is also enough, even if there is no territorial control. Now, the paradigm cases here are based on detention abroad, specifically the detention camps instituted by the American military in Iraq, for example, but also embassies and consular institutions. Usually this model, even though one might say lethal force is the ultimate form of control, does not include that. So it needs to be control over more than one situation in a way of that individual. This might have been modified, at least at the ECTHR, by Carter against Russia, which this case was about the assassination of an individual who was in the UK, but it could be attributed to Russian state organs. So, but it's not certain how far this modification will go. Finally, the Human Rights Committee, in a relatively old decision, that's a UN body, has said that a special connection between an individual and a state could also create extraterritorial jurisdiction. I'm including this here not because of the substance matter. Lopez Burgos was about the renewal of a passport, or rather the refusal to do so. But I want to say that in every case, in every model, in all the accepted case law and decisions, it is always about a connection between the duty-bearing state and the right holder as an individual. So that's what we're looking for in the jurisdiction. This will become important when we move on to the next step in my presentation. So I wanted to emphasize that. Can we switch slides? Now, recently, these models have been contracted again, especially at the European Court of Human Rights in Georgia against Russia, number 2. This was a case that concerned the Georgia-Russia war in 2008. The image you can see is Gori in Georgia under attack during the hostilities fought during that war. Now, of course, hostilities and armed conflict are not climate change, but I wanted to give this case as an example of how even seemingly broad extraterritorial jurisdiction models can be contracted in the face of really complex cases, because this is what the court has done here. It invented, specifically for this case, a difference between the stages of the conflict that were sort of looking like occupation. Recall that's the basis, the paradigm for the territorial model of jurisdiction, and active hostilities, and then the court excluded active hostilities into time frame there from a finding of jurisdiction extraterritorially, because it said there was no personal or territorial control. Now, what is interesting for our cases, for our purpose today, is the reasons the court gives for this. It says, well, we draw this distinction because of complex fact patterns, an overwhelming amount of evidence, a large number of potential victims, and law other than the convention applying. Now think about climate cases with an extraterritorial component. This is exactly what we're talking about. We're talking about complex fact patterns. We've heard about causation and the scientific aspects of these cases. An overwhelming amount of evidence, because even though climate attribution science has made really great strides, particularly recently, this is very complicated. There's a lot of evidence to consider. And then there is a large number of potential victims, because climate change is, as we've also been emphasizing today, is a global affair. And finally, we have environmental law applying also to these issues, not just the ECHR. So the problem with this case is that if the court wants to declare the climate cases with an extraterritorial component inadmissible, it can rely on this. I don't hope that it will, and I actually don't think so. But just to say that there is definitely some nervousness, shall we say, in the system about exactly such cases. Can we switch slides? Moving on now to factors that have been used to expand the extraterritorial jurisdiction models. Now we're getting into the area of reasoning that is relevant and that has been used in climate cases as well. The most prominent examples here are, interestingly again, at the European Court of Human Rights and the Committee on the Rights of the Child in cases against France and Argentina. One is Saki, which you've already heard about more than once. Now, there, the committee relied on the fact that Argentina would have had capacity to aid, and or capacity to act, and that the damages it could have prevented were foreseeable. It was quite liberal in doing that. But that was perhaps aided by the fact that overall the case was found, or the communication was found, inadmissible. And then we have LH and HF against France at the committee, the Child Rights Committee and the ECTHR respectively, different initials, same case. And there the Committee on the Rights of the Child relied on capacity and nationality again. These were cases that concerned the repatriation or the lack of repatriation of French children born in refugee camps in Syria. So born to French parents, mostly people who had left to fight for ISIS and then ended up in refugee camps. And the CRC relied on the fact that France could have acted and on the fact that these children were French. So we have an expansion specifically in the capacity and foreseeability factors. The nationality one is of course tricky because this will not aid climate cases in general. Perhaps the fact that these children were French and then there was already this connection established, this also made it more plausible to rely on the fact that France can do something, could have done something. So the ECTHR it took a different route here and insisted on special features of this case. So this is relevant because it's an expansion of extraterritoriality basically on an ad hoc basis. And as we've heard in other presentations before, it aligns it to the merits of the case, even though it's an admissibility question. This is interesting for the current climate cases because the applicants, in fact, relied on this and listed special features, for example, in Duarte Agostinho, and I'm just going to say what they listed. This is in paragraph 55 and 56 of their submission to the Grand Chamber, just in case anyone's interested in the details. So they said that the special features of this case are control over convention interests. So the respondent states have control over rights rather than individuals. You see, we're already moving away from the accepted story. There is a causal link between activities and effects, that they were foreseeable and that the effects were long-lasting, and that the respondent states had control over the source of harm. Now, the problem with these special features is that the applicants in Duarte Agostinho list, these are different special features from the ones that the court used in HF against France. And this points to a problem of expansion aligned with the merits. It is a threat to the legitimacy of the court because it's not principled, or there is a danger that it is not principled. And this opens all sorts of routes for objections, such as the ones that Corina has just outlined. Can we switch slides? Now, for climate change cases specifically, what bodies have done, right? Now I've given you a story of extraterritoriality in general, and now we're looking at climate change more specifically. Whatever body was faced with a climate change case with an extraterritorial dimension, they did not actually engage with any of the accepted models. In Saki, the models and case law and accepted ideas about extraterritorial jurisdictions were cited, but then the committee departed from them without giving many reasons why. That again, perhaps aided by the fact that it was inadmissible for other reasons. Then the famous advisory opinion at the Inter-American Court of Human Rights does the same. It cites all the ECHR case law, all the Human Rights Committee case law, like everything that I've just given you, or something in the vicinity, and then departs from them, from these issues, from their models, and doesn't give much reasons why. But what all of these cases show, they have an important commonality. And now for the Duarte Agostinho case, I'm just relying on the arguments of the applicants here. All of them require that the jurisdiction is established not by control over an individual that is abroad, but by control over the source of harm. We have heard that before today. But this is a major shift. I've just given you a story where courts and bodies for close to decades now have taken great care to carefully establish a connection between a state and an individual. And suddenly we're saying, well, the effects of this source of harm are such that this connection is no longer required. Instead, we're going to focus on the source of harm and who controls that. Next slide, please. This could be a really good thing because it would solve a lot of problems, right? It would solve the problem of causation in many cases, because the emissions are relatively easy to link to their emergence, but not to their effects. And this is what we need, right? It's a bit reminiscent of what we discussed, of what was discussed earlier today about the Brazilian domestic litigation, where they start in the middle in a way. So this would be a way of doing that in the human rights context, and it shifts the focus on the perpetrators rather than on the victims, maybe alleviating some of the problems with victim status or similar concepts in the human rights landscape as well. Now, there are some issues, though, also with this, and here I'm going to explain why it really is a paradigm shift that is being argued for here. Extraterritoriality will lose most of its importance because it will make no difference where cases come from. This is a problem because states are really nervous about this. This is why the hearing on the 27th of September in Duarte Justino was all about that. The renewed attempt to get the right to a healthy environment recognized that the Council of Europe is also very much influenced by a nervousness of states about that happening. As Stanislava has outlined, and as I will reiterate, there could be positive obligations created here, even for minor involvement. We have to remember that even major emitters on their own are not responsible for all that much in the grand scheme of things. And then an additional problem is that if the hope is to use human rights more effectively to address climate injustice, which I think is the thrust of all of these cases and is definitely what we should be doing given how much injustice climate change creates, it would, even the control over the source of harm would need to be supplemented by ideas of relative capacity. For example, countries like Indonesia are responsible for quite a lot of annual emissions at the moment because of deforestation, if we count a change in land use also. But that is not where we want to get reparations or loss and damage or redistribution if we want to address climate injustice, right? We want to have human rights be responsive to the fact that past emissions and historic emissions are just as important. But the control over the source of harm does not give you that in and of itself. It would need to be supplemented by other concepts. And that would then in itself be another paradigm shift for human rights law. And finally, and this is where I want to end because it gives it presents a final challenge, but it also is an entry point for, I think, hope and prospects. The justification of such paradigm shifts is really difficult to do. This is for all the reasons that Corina has just outlined, that these systems are under stress as it is in terms of their legitimacy. And that expanding duties can only be done if it's done in either consent basis, and even then in a very principled and well-justified manner. It cannot be done, I don't think, by relying on special features. It cannot be done by relying just on a link to the merit. It just requires a lot more deeper thinking. Now, I don't think this is a reason not to do it, but I also think that the sheer dimensions of the challenge are often not represented by hopeful reasoning, or not as well represented as I would like. And I think my presentation today and my work overall is perhaps just a plea to try and do more of that, and to be honest about how fundamental the changes that are being argued for really are. Thank you very much for your attention. That's all for today.
Thank you very much, Leah. It's a life-changing perspective that you brought here. Thank you so much. We are now going to listen to our last speaker, Katalin Suljok. She's an assistant professor in international environmental law and climate law at Witwatersrand University. She's the chief legal advisor to the Ombudsman for Future Generations. She has a PhD in international law at Witwatersrand University, an LLM at Harvard, and a BS theological Bachelor of Science in biology. Katalin, thank you so much. We are looking forward to hear you.
Thank you, Madam Chairman. Let me just pull up my slides quickly. Is it visible? Can you see it? Okay, wonderful. So I'd like to first thank the organizers for having me here today. It's a real privilege to talk about after such wonderful colleagues, and also have to confess I feel to be in quite a tight spot, being the last speaker at the end of this marathon session. But I'd like to thank all the attendees to bear with us today, and I promise to be short and concise and be mindful of the time that I was assigned. So the organizers asked me to talk about the difficulties that international courts and courts in general face while they grapple with interpreting and understanding climate science and climate adjudication. So this research is based on my previous work that I've done into the environmental practice of international courts. And I found that international courts are very inventive in finding ways of circumventing science. They try to look for reasoning and ways of justifications in which they do not need to actually reflect on scientific evidence too closely, because it has so many difficulties, admittedly, to interpret science in a legal setting by legally trained judges. But when we turn to a climate adjudication, I think there are even more reasons that can be cited that would warrant for attaching a closer or more direct role to science in deciding climate disputes for various reasons. So starting with the obvious, climate research often directly drives novel legal claims. So we see that lawyers can frame the climate crisis in very creative ways, and the emergence of these novel legal framings are often directly driven by our growing knowledge about climate science, such as attribution science, or all other aspects of the climate system. So we also see that legal claims in climate cases often have inseparable ties to the core. So the scientific knowledge has inseparable ties to the legal claims, which also means that if courts do not want to or are not willing to reflect on climate science too closely, they would run the risk of not deciding the core controversy, the core legal dispute. I also argue in this research that I believe that a closer engagement with science on part of judges is also warranted for reasons of sociological legitimacy, which means that the parties to the dispute and the larger public will also lose faith in courts if they believe that the courts do not appreciate those aspects of the case that they deem legally relevant. And we see that parties, especially the applicants, heavily rely on the science. They submit a large amount of evidence, and I think that they, in a way, expecting the courts to reflect on these issues as well. And finally, I also believe and argue that simply put, if courts would marginalize or refute scientific knowledge in their judicial findings by descientizing these disputes entirely, they would run the risk of making epistemically illegitimate judgments, in the sense that a judgment which runs against established scientific knowledge, it would easily lose of its convincing force. So I also believe that these reasons stemming from the importance of epistemic legitimacy also calls for putting scientific knowledge in a more privileged place in the judicial reasoning. But of course, doing so is not easy, and I'm ready to admit that it has many problems for a court of law. I see in my research courts as translators. So I do believe that a core function or core part of the judicial mandate in climate litigation is to translate scientific input to legally persuasive findings. So of course, climate science provides a wealth of information for courts, but unfortunately, these climate and scientific data do not directly answer the judge's legal questions. So in a way, we need legal answers to the legal questions. And I think that sort of a simplistic model of this translation looks like that scientists, experts will provide scientifically legitimate evidence in the sense that they are these pieces of evidence should be robust and valid and persuasive from a scientific point of view. So they should be produced in conformity with the accepted knowledge production conventions of the scientific discipline. So once we have the scientifically legitimate evidence, this will be submitted to the court, and courts will be in the rather difficult position of translating this scientifically legitimate input into legally legitimate findings. Now, courts, as you may suspect, rarely reason in the language of scientific rationality in their judgments for understandable reasons. So when you look at the judgment in a scientific dispute, such as an environmental dispute or a climate case, you would find that the judicial reasoning often rely on legal reasoning, legal logic, legal rationality. For instance, they set up presumptions that are persuasive due to reasons of legal logic, or judges would argue with on the basis of everyday knowledge, based on intuitive benchmarks. So there are many ways of engaging with scientific rationality. Courts may use either scientific or legal or intuitive benchmarks. And my research is primarily interested in the sort of epistemic questions and epistemic difficulties that courts face in selecting the appropriate way of reflecting on scientific evidence. So whether the scientific legitimacy of a scientific input, of an expert input, is a prerequisite for making a legally legitimate judgment in the case, or perhaps legally legitimate decisions can be crafted irrespective of the scientific legitimacy of their finding. And then perhaps the most difficult scenario concerns the dilemma that courts face when scientific, legal, or intuitive rationality in the given case would point to different directions. So how the courts should argue when scientific and legal logic point to different directions. Of course, I do not have time to really go into details, but I'd just like to briefly flag that if you look at the climate case law, you would find that courts are mainly dealing with three types of scientific evidence. They usually rely on IPCC reports, or they use the scientific opinion of domestic climate advisory bodies, and sometimes they cite, and anyway, the parties rely on a great number of scientific publications, like individual journal articles. And I'm most interested in looking at the sort of epistemic justifications that courts offer when they examine or accept any of these types of evidence. So when we look at the IPCC reports, we see that courts are comfortable with citing the IPCC reports because they represent negotiated science, they represent consensual findings that were accepted by the UN body. So in this sense, a court can safely refer to IPCC standards and IPCC reports in a climate judgment because they can rely on the scientific knowledge embodied in this IPCC reports without having to actually engage with the scientific rationality itself, without actually revisiting or thinking about the robustness, the scientific legitimacy of these of the findings that are contained in the IPCC reports. So in my view, when the courts argue based on IPCC science, they are in fact arguing on the basis of legal rationality, because the IPCC reports, the persuasive force of an IPCC report, in my view, is stemming from the international prestige, the legal authority of the issuing body, the IPCC itself. And in this way, reasoning on the basis of IPCC reports provide a convenient reasoning method for courts. And I think we see quite similar trends in judgments which rely on the reports of domestic climate advisory bodies. Again, we see that the opinions of such bodies are accepted on the basis of legal rationality, on the basis of the mandate and prestige of such bodies and committees. And I think that the most intricate problems arise when courts are asked to confront with and use individual journal articles or even preprints, so like individual scientific publications that were not yet touched upon or cited by or in the IPCC reports. And if you look at the national courts practice, we see that jurisdictions use various legal criteria in selecting whether the courts would accept a certain journal article. In many of the jurisdictions, they use or they check whether the individual study was subject to peer review, or the judges would look at the experts' credentials and would decide based on these credentials whether to trust this individual expert opinion. Now, in these cases, I think that the courts are actually relying on intuitive logic, because if you think about the scientific robustness has in fact nothing to do with the expert's credentials. So if courts are solely relying on such intuitive everyday benchmarks of the expert's credentials, then they, again, do not really engage with the scientific arguments that are represented in these studies. And such methods can, such intuitive reasoning methods can even run against established scientific knowledge, because even a lesser known expert can provide the court with useful information. So it may not be the perfect way of approaching a science in a climate litigation. So like very briefly, some preliminary conclusions, or perhaps I would pose some further questions. So how courts can manage and deal with climate science in a legitimate way in their reasoning. If we look at the case law, we see that courts appear to be most comfortable when they can reflect on IPCC science. So when they can reflect on scientific knowledge on the basis of legal logic and legal rationality. And the problem is that with the increasing sophistication and diversification of legal cases, the IPCC standards may not be enough in many cases. So the IPCC standards, for instance, they are silent on national fair shares, and they are not particularized enough for answering the judge's legal questions. So I think that we increasingly see that courts need to venture beyond the cozy confines of the IPCC reports, and they could only do so, in my opinion, if they are developing a more open approach, a more active approach towards science and scientific rationality. They must use their evidentiary capacities intensely, and they must engage in evidentiary hearings in order to understand the scientific basis of this controversy, especially when their question cannot be answered based on IPCC data. I also believe that there is a limit to which courts can sideline science. So even though it is hard for a court of law to engage with science, I think that they cannot entirely escape these difficulties and this difficult task. I think that they can safely and legitimately reason with a non-scientific rationality in certain cases. I think there is an appropriate, legitimate room in the judicial toolbox for intuitive reasoning and legal reasoning as well, but only if such non-scientific reasoning techniques do not undermine the scientific correctness, the scientific robustness of their conclusions. So I think the sort of the ultimate benchmark would be that whatever the courts can reason in many ways, but the ultimate conclusion should not run against established scientific truth and state-of-the-art, fast developing scientific knowledge. And of course, identifying state-of-the-art knowledge in itself is a huge challenge. I do not want to underestimate them, such challenge, but I do believe that that courts should be aware of the fact that scientific knowledge carries strong cognitive authority. And this strong epistemic authority, this convincing force, which is attached to scientific knowledge, is hierarchically juxtaposed to legal authority. So a court of law cannot invalidate and run against and repudiate established scientific knowledge based on legal logic, because that would be just arbitrary from an epistemic point of view, and therefore unconvincing in the public's eye. So at the end of the day, I think that proper engagement with science is important for courts in order to buttress their own legitimacy capital, the convincing force of their own decision. And I also would like to flag that, of course, there is no one size-fits-all solution. So there's no one single ideal way of integrating science, because judicial reasoning is deeply and closely tied to different legal cultures. So of course, the best for sort of the epistemically most appropriate ways of reflecting science may also be culturally dependent. So they may also vary across jurisdictions. And altogether, I believe that that courts should be more willing to develop a basic understanding of the scientific dilemma behind the legal cases. Of course, climate science is extremely complex, so it is not an easy task. But I don't believe that courts should, become super experts, or they should acquire PhD training in climate science. This is not my point. I think that judges are extremely intelligent, and they possess all the necessary cognitive training and capacities to delve into the depth of these cases, to really appreciate the scientific dimensions of the climate disputes, which are in fact inseparable from the legal dimensions. And I think that if they develop a sort of basic understanding of the of this fast developing field of scientific knowledge, and then they can select the most appropriate reasoning style, which would be epistemically legitimate, so which can ensure that their findings and their conclusions do not undermine or run against outright, in an outright way, established scientific knowledge. And I think I'm going to stop here, because I need to be conscious of the time. So thank you.
Thank you, Katalin. We are not running out of time. We run out of time. So we cannot have a thorough debate around the presentations, but still I will ask the speakers if they want to comment on each other's presentations. I will not open to the audience because it's really late now. Corina, do you have any comment? No? Or Leah? Or Kathleen? And Narita, I know she hasn't. Okay, so it's really late, and it has been a long day. Oh, Pedro, sorry, I was not seeing you. Do you have any comment?
It's not really a comment, just to say two things. First, to say that within the African Union human rights system, there's also a possibility of advisory opinion, and also to say that it seems to me, after hearing different interventions, that the climate change issues maybe can be addressed better in the context of the interstate dispute, because we are talking about the policy, the political options, and it will be difficult in the context of the litigation between individuals and state to address this kind of the challenges the climate change issues raises. And finally, to thank the organizers, Professor Kalarmadu, for joining me, or for giving me the opportunity to join this panel and share different experience and also learn. Thank you very much.
Thank you, Pedro. So it's time to wrap up, but before wrapping up, Eloisa has a surprise for us.
It's not that great, so don't get too excited. I think it's good, but not that great. I'll ask Paulo to share the PowerPoint, please. Last year we had a conference on cities in the age of climate change, and in a few days, World Cities Day, which will be October 31st. Here is the table of contents. So you'll have 3 texts in English and 3 texts in Portuguese. So it's completely bilingual. The first text from Armando Rocha, who we shamelessly exploited this morning here, is a very interesting text on governance and climate governance and the role of cities according to the law. Of course, there are a lot of political aspects into governance, but of course we are legal scholars, so it's a focus on the legal role of cities in the governance and climate governance. As you all know, cities are not states actors, so they're not subjects of international law, but they have a very relevant role. Secondly, we'll have a text from Matteo Vermelha on basically the experience in Belgium that is, as we all know, a very fragmented state, and how cities have a crucial role in establishing cooperation and implementing goals considering climate change targets. Thirdly, a text of mine concerning climate change litigation, and basically a study on how our city-led litigation cases, so cases that are brought to courts by cities, if they are different from litigation cases in general. And then we will move on to the Portuguese written part of our text, of our book. First from Gabriel Vedi, I'm not sure how to pronounce it, on climate change and the role of cities in Brazil. Thirdly, a text from Margarida Vidal Sampaio, also here, concerning extraterritoriality, so a topic we just heard of. And thirdly, a very brief testimony from Carlos Ribeiro, who is the head of, well, I would say an experiment. So he basically leads the landscape lab in a city in Portugal, who's trying to develop not only climate change measures, adaptation measures, but also in general sustainability. So this is, can't move the slides. Could we please move the slide? Okay, this is the full table of contents, as you can see. Please move to the next slide and the next and the next. So this will be available next. Okay, this will be available at the Lisbon Public Law Research Center website. And please, to the next slide. I would now use this moment for propaganda. So Lisbon Environmental Law is a cluster that it has organized this event. It's a cluster at the Lisbon Public Law Research Center. And well, of course, if you are interested, please move to the next slide. If you are interested, of course, you can always get in touch with us. This is our email. We will be having monthly workshops and etc. A lot of things. I won't get you even more tired. So this will be it from us today. And going to the next slide here, we hope that this workshop was excellent for you. We don't know. So in the chat, you will find a link for answering a survey on the quality of this workshop. And for those of you here, you can also do so by, using this very fancy QR code. And that is it from us. So we hope this was great. If not, please let us know so we can do better. Okay.
Thank you. Thank you so much to the speakers online and to the audience, and have a nice evening.